Hi everyone, thanks for joining us tonight. I was just waiting a few more minutes on people to join, but I think we'll make a start now. It's 5:35. Welcome to today's presentation, which is Your Rights at Work. It's part of the Victorian Law Week. Thanks for being here and joining me after work. My name's Jennifer. I'm the Principal Lawyer of the Employment and Equality Law Program at Westjustice. I'm presenting today from the lands of the Wadawurrung people, and I acknowledge them as traditional owners and pay my respects to elders, past and present, and extend that to any First Nations people here with us today. I also acknowledge that sovereignty was never ceded, and it was and always will be Aboriginal land. So, first of all, just who we are, why we're doing this session. Westjustice is a community legal centre. Although we do receive funding from the government, we're not a government agency. We're independent, not-for-profit community organisation. We're also not part of Victoria Legal Aid. We're separate from them as well. We provide free and confidential legal advice to people who live, work or study in the western suburbs of Melbourne. And to give you an idea of where our catchment is, we go from Maribyrnong, Hobsons Bay and Wyndham. And for employment law, we also serve the Brimbank area. So that means that we help people with employment law advice all the way from Footscray all the way out to Melton. That's a catchment area of almost 1 million people. And in the 2021 census data shows that that's the fastest multicultural community, fastest growing multicultural community in Australia. So in particular, in relation to this particular topic, we can actually provide free legal advice to people who are living, working or studying in the western suburbs who experience workplace discrimination or sexual harassment. And our contact details will be available at the end of the presentation if you fall in that catchment area and would like to get some legal advice about your own personal situation. So what are we going to be talking about in the webinar tonight? So we're going to go through your rights in relation to discrimination, sexual harassment and bullying at work. We're going to talk about the laws that protect you from these things, the legal tests and some examples of each of those. And then we're going to look at what it looks like to pursue a legal claim. And then we're going to talk about some practical tips if this does ever happen to you at work. Feel free to use the Q&A or chat function during this presentation to ask questions. After each part, I'll try and check into those and see if there's anything before we move on to the next part. It is just me that's running the webinar on this end. There's no tech support, so bear with me while I navigate the different screens. So there's a bit of a disclaimer, as you might always experience in a legal information webinar. I want to go through a few things. So it's important to note that this session is legal information only, doesn't constitute legal advice. I am happy to answer those questions as mentioned, but if it's about your own personal situation or about a friend or a family member, I won't be able to answer it in public. It's not really appropriate to address people's personal circumstances in this kind of forum. So what you can do is you can contact me separately, or you can call Westjustice and book in a time to see a lawyer, or you could even talk to your union if you've got one. If you don't understand something that I say in the session, please pop a comment in the chat or in the Q&A, and then we can try and make sure that it's all clear for you. Okay, part one of this presentation. We're going to take you through some of the laws that protect you in the workplace. And this is really just to give you an overview of the different laws that exist in Victoria, because employment law can be one of the most complex areas, I think, in daily life that we have to deal with. Before I start on the topics, it is important to note that all non-citizens in Australia who have the right to legally work here do enjoy the full protection of Australia's workplace laws. So that means that all migrants, asylum seekers, and all other people with a right to work in Australia have the rights we discuss here today. We do often hear in our practice, we work with migrant communities a lot, that they think that because they're not a citizen, because they've come into Australia recently, that they don't have these full protection of the law. That's wrong, they do. I also wanted to note that there might be some things that we discussed today that might trigger you or make you feel uncomfortable. We will be talking about sexual harassment. So please just look after yourself during this session. And if you need to leave the room or mute me or leave the webinar entirely, obviously that's more than fine for you to do that. Now, this is probably a bit overwhelming. There are a lot of acts up on the screen here. It's really an illustration to understand that there are actually a full range of laws that protect you from unlawful behaviour in the workplace. In today's session, we are going to specifically talk about the laws that protect you from unlawful discrimination, sexual harassment and bullying, and those are broadly anti-discrimination laws, employment laws, and there are some other ones that apply as well. So, anti-discrimination laws, we'll start with them. They protect you from unlawful discrimination and sexual harassment in the workplace, but also in other areas of protected life. And we'll go through some of them in a minute. In this sense, anti-discrimination laws are actually broader than employment laws because they cover conduct in a range of circumstances that are not just employment. There are two types of anti-discrimination laws that cover you if you are a worker in Victoria. There are state-based laws, and then there is federal law. So on the list there, we have the Equal Opportunity Act. That is Victoria's State Equal Opportunity Act for anti-discrimination law. The ones that are listed underneath it, the Sex Discrimination Act, the Race Discrimination Act, the Age Discrimination Act, and the Disability Discrimination Act, those are the federal anti-discrimination laws. And sexual harassment is covered by the Sex Discrimination Act federally under anti-discrimination law. And it's important to know that there are different laws because they have different legal tests for what constitute discrimination. They're slightly different. They're mostly the same, but it's in relation to sort of who can be held liable and legally responsible for the conduct. There are some differences that make that might impact your claim. And also there are different time limits that apply depending on the federal and the state jurisdiction. And we're going to talk about time limits later on so that you're aware of those differences. That also means that it's really important to get legal advice before you lodge a claim under state or federal law to understand both the strength of your claim under the different legal tests and to understand which is the right path for you. Now, turning to employment laws, these sit alongside anti-discrimination laws and do exclusively focus on your rights at work. Employment laws that you will have heard of, probably, and I hope so, that you've heard about the Fair Work Act. That's the #1 employment law in Australia. In Victoria, we have the Occupational Health and Safety Act, and we also have Workers' Compensation Act. So Fair Work Act is a federal law, and the other two are Victorian laws. These laws operate to protect you from bullying, unsafe work practices, adverse action, and discrimination at work. The Fair Work Act also includes protections to obtain specific orders relating to bullying and sexual harassment from the Fair Work Commission, and that's while you're still employed. The Fair Work Commission, that is, now also has the ability to hear disputes about sexual harassment, and that's a brand new jurisdiction that only happened in March this year. I'll talk about that a bit later on. Now, there are some other laws that I wanted to mention that they exist to protect you in the workplace, but they're outside employment law and anti-discrimination law. We won't actually be talking about these today, but if it's something you're interested in, you can send us a message and we can provide you with some more information about it. So, for example, criminal law might apply in the case of sexual harassment where there is a criminal element, like a sexual assault. Victims of crime compensation. Again, in the case of sexual harassment and assault, there is a whole regime where victims of crime are able to seek compensation, and you usually need someone to make an application for you, and getting legal advice is really important. There are also common law claims, and there's also, for example, the tort of negligence. Employment lawyers don't tend to make these kinds of claims, but we can find other people that we can refer you to if you're interested in that kind of information. And then finally, in Victoria, we have the Racial and Religious Tolerance Act, which is an anti-vilification law. So that's a huge range of acts that lawyers have to be across in the employment space. And we're going to touch on a few of them today. And I can see there are no questions, so I'm just going to keep moving. So this is part 2, the basics. We're going to give you a broad overview of the legal definitions of discrimination, sexual harassment, and bullying. Often we might have a gut feeling about something that is wrong in the workplace, and those gut feelings are really important in helping us understand when we might need to get help. But I want to get you an understanding of the legal test so you can have a much clearer understanding of what behaviour is okay and not okay under the law. So we're going to start with the definitions, the legal definitions of discrimination, sexual harassment, and bullying. The reason I think this is important to do, because the legal definitions are often different to what we have in our common understanding or colloquial understanding of these terms. And if we understand what the legal definitions are, then we can start to understand what behaviour is lawful and unlawful. So discrimination, you can see there that there are 3 different types that are listed. So the first is direct discrimination. That is unfavourable treatment because of a protected attribute in a protected area of life. We talked about the protected area of life before. That's, for example, employment law. In employment. So indirect discrimination, however, is different from direct. It is where there's an unreasonable requirement conditional practice that disadvantages a person or a group of people with the protected attribute that occurs in an area of a protected area of life. We're going to go into some examples of these in a minute so that you understand how it works in practice. And then a third form of discrimination, which is standalone, and you don't have to prove the other 2 definitions, is failure to make reasonable adjustments. And that's and also accommodation of parental and carer responsibilities. We're going to go into that a little bit more detail later on. For sexual harassment, this is unwelcome conduct of a sexual nature, for example, advances or requests for sexual favours, that makes you feel offended, humiliated, or intimidated. And this conduct occurs in circumstances that a reasonable person would anticipate the reaction that you had. And of course, it has to happen in a protected area of life, and we're talking about the workplace. Finally, bullying. Bullying has got a much more simple definition compared to the others. That is behaviour that is unreasonable. It has to happen more than once, and it creates a risk to health and safety. So repeated unreasonable behaviour that creates a risk to health and safety to the person or a group of people. Now, discrimination. We talked about it needing to be in relation to a protected characteristic or attribute. So some of the examples here: age, race, sex or sex characteristics, gender identity, disability, religious belief or activity, sexual orientation. It's also important to know that includes characteristics of protected attributes. So, for example, using a wheelchair is a characteristic of certain disabilities. So when the discrimination relates to the use of the wheelchair as opposed to the disability, it would still be counted. And as mentioned, for conduct to be covered, it has to be occurring within a protected area of life. And we've talked about employment, but it's important to know that employment includes when you apply for a job, as well as when you are in the job itself. So job applications are covered by anti-discrimination law. Other examples are education, goods and services, when you go to the shops or when you go to a restaurant or a cafe or to a nightclub, and accommodation as well. So as mentioned, direct discrimination is when you've been treated unfavourably, and a substantial reason for that unfavourable treatment is because of a protected attribute. So if we break this down a bit more with an example, here is an example of direct discrimination. So in this example, Amir has applied for a job. When he doesn't hear back and he asks if they've considered the application, the employer says, "I'm sorry, Amir, we've employed people from your country before. You lot just don't fit in." Now, in this case, the action can be characterised as rejecting a job application. And this is unfavourable to the applicant because it's occurred because of his race. It's unfavourable because he hasn't been offered the job. You can see in this example the link between the unfavourable treatment and the person's protected attribute, their race, is very clear. There are other types of direct discrimination that you might hear of or you might see. For example, a boss or a colleague making sexist remarks in the workplace, a colleague making racist comments in the workplace that make you feel uncomfortable, calling you names, for example, racist names, or a worker being fired because they have parental or caring responsibilities. Those are just some examples of where there's been unfavourable treatment and that's directly related to the attribute. Indirect discrimination is a little bit trickier for people to understand. As I said before, it's where there's a condition, rule, or practice that unfairly disadvantages a group of people with a protected attribute. Indirect discrimination is something that is usually a bit more harder to prove. So let's look at this example. The woman is saying, the company has decided that all employees in customer-facing roles must be between the ages of 40 to 55. And the employee says, but I've been in a customer-facing role for a long time with this company and my age is not relevant. So in this example, it's a rule in the workplace that's been created. The rule impacts on the people who are outside the ages of 40 to 55, so a group of people with a protected attribute. It specifically detrimentally impacts this employee who, for example, could be 20. The rule doesn't appear to be reasonable because the boss hasn't given an explanation for why customer-facing employees need to be of that age group. If it's not a reasonable rule and it unfairly disadvantages that group of people with the attribute, then it's considered indirect discrimination on the basis of age. I'm just checking the chat to see if there's any comments. No, I can't see any. Great. So we're going to move on to reasonable adjustments. So as I mentioned before, this is a third form of discrimination where you don't need to prove it's direct or indirect discrimination. It's a standalone cause of action or claim that you can make. So if you have parent or caring responsibilities and you require some flexibility in the way that you work, your boss may be obliged under the law to try and reasonably accommodate your responsibilities. So types of accommodation could include physical adjustments to the workplace. So for example, places to breastfeed or express milk, flexibility with your work hours, flexibility with work practices, so working from home. For workers with disabilities, there is also a similar kind of third form of discrimination, and that's failure to provide reasonable adjustments. You have the right to ask for reasonable adjustments to help you do the inherent requirements of the job. So, for example, a worker who uses a wheelchair, a reasonable accommodation or adjustment might be installing a ramp so they can access the office where they need to work. Or for a person with low vision, purchasing screen reader technology to help them use the computer. The key to whether your boss is actually required to make these accommodations or adjustments under the law comes down to a few things. Whether you require it because of your disability or parental or carer responsibilities, whether the adjustment or accommodation is reasonable in all the circumstances. And so what that means is that there's a range of factors that we need to weigh in assessing whether the adjustment or accommodation is reasonable, like the cost of making the adjustment and the impact on the workplace or the workload of other people. So it's a balancing act. So for example, sorry, I was just double checking there wasn't a slide there. So for example, a parent who has to pick up their children early from school at 3:30 might ask their boss if they can start earlier or finish earlier or go down to part-time work. A boss doesn't have to agree to the request if it's not reasonable. So if the parent works in a retail store that has set opening hours and they have to be there to face the customers, it might not be practical for the shop to open at different hours or accommodate their shift request. In order to access these entitlements, we do recommend that you have a conversation with your boss about your needs. And if applicable, for example, if it relates to a disability, or a reasonable accommodation of a disability in the workplace, you should provide evidence like a medical certificate. Okay, so moving on to sexual harassment. So sexual harassment. This involves unwelcome conduct of a sexual nature, as we mentioned before. So advances or requests for sexual favors. That conduct must make you feel offended, humiliated, or intimidated. And a reasonable person would anticipate that reaction that you had in all the circumstances. And obviously it has to occur in an area of protected area of life, so work. So an unwelcome conduct, unwelcome means that you personally did not welcome the conduct. It's considered a subjective test. It's about the evidence of the person that's experienced the conduct and how they felt about it. Conduct of a sexual nature can include things like sexually suggestive behavior, staring at someone or leering at them, brushing up against them intentionally, sexually suggestive comments or jokes. Unfortunately, sexual assault, sexually explicit emails or messages, requests for sex or sexual favors. It also can include unwanted touching and hugging and kissing, comments or questions about someone's appearance, what they're wearing, or their body, questions about their sex or dating life, asking someone on dates repeatedly, and obviously putting up pornography or sexually explicit material on posters or screensavers or sending it by text message. Those are all things that considered conduct of a sexual nature that would be considered sexual harassment. So it is very important to get legal advice if you are subject to, or if you've witnessed any of the behaviours that make you feel uncomfortable in the workplace, such as the ones discussed. And we'll go through later on, obviously, what the options for making a complaint could be. I think it's important to note that you do have a right to have a safe workplace free from sexual harassment, discrimination, and bullying, which we're about to cover. And you have the right to make those complaints and assert them in the workplace. So the final area that we're going to talk about definitions is bullying. Bullying covers a broader range of conduct than discrimination and sexual harassment, because it doesn't require you to establish a link between unfavourable treatment and a protected attribute. Bullying instead is repeated unreasonable behaviour directed at an employee or group of employees that creates a risk to health and safety. Now, as I should explain, health and safety includes your physical safety, but it does also include your psychological safety, so your mental health. So examples of unreasonable behaviour include a colleague or a worker being aggressive or intimidating towards you, using abusive or offensive language, mocking you or humiliating you in the workplace, excluding you from group activities. And that conduct constitutes a risk to your health and safety and might have an impact on your ability to complete the job. There is one important caveat to all this, and a carve out that we need to mention, is that reasonable management action doesn't constitute bullying. So what might be reasonable management action could include things like reasonable directions about how to do your work, constructive feedback, extending a probationary period when you're not performing the job in the way that they need you to. So if you're in the workplace and you're being bullied, it is important to get legal advice about the claims available to you. And we'll cover some of them now. So part 3, legal claims. I hope that part 1 and 2 has given you an understanding of the kinds of laws that protect you and the legal tests and definitions involved. I'm just going to quickly check the chat to see if there are any questions. No, great. So the types of claims. I put this slide in here to give you a picture of the different types of legal claims that might be available to you if you've been discriminated, sexually harassed, or bullied at work. I just want to make it clear that there may be other claims available to you, like we mentioned at the start, under other laws, but these ones we're talking about today are the most common. So I'll start in the middle with the Fair Work Act. So as mentioned before, there are stop orders that you can make get applied to the Fair Work Commission for. A stop sexual harassment order is most helpful if you are still in your job and you want to continue working there, but you want the incidents of sexual harassment to stop. And you've already tried to raise it with management, but the perpetrator hasn't stopped harassing you. You do, as I said, have to still be employed at the company to get this order made. Similar to a stop sexual harassment order, you can get a stop bullying order from the Fair Work Commission. Now, this is most helpful if you want to continue working at the workplace, but want incidents of bullying to stop. And again, you've tried to raise it with management, but the perpetrator has not stopped their behaviour. Like the stop sexual harassment order, you have to still be employed. The Fair Work Commission just won't make the order if you've already left. And it's not the place to go if you want to seek compensation. Under the Fair Work Act, there's also the ability to apply to the Fair Work Commission to deal with adverse action, discrimination, or a sexual harassment dispute. And as I mentioned earlier, that is a new jurisdiction that the Fair Work Commission has recently been given. So adverse action discrimination taken by an employer includes doing, threatening, or organising any of the following due to a protected attribute, similar to the ones we listed earlier. So dismissing someone, injuring them in their employment, altering their position to their detriment, discriminating between one employee or other employees, refusing to employ someone, or discriminating against a prospective employee on the terms and conditions that they offer. And as mentioned, the sexual harassment dispute jurisdiction, that is for conduct that occurred from 6th of March onwards this year. And sexual harassment has the same definition as in the sex discrimination, similar to what we just discussed. So, anti-discrimination law, claims under this, there are state or federal claims that can be made. This is the kind of claim that can be brought while you are working somewhere or after you've finished working there. So you can do it before or after. Claims under anti-discrimination law focus on showing that incidents of sexual harassment or discrimination have occurred and outlining the loss that you've suffered as a result of that conduct. So what that means is if you're successful, you could be entitled to financial and non-financial compensation. That includes lost income, pain and suffering, or hurt and humiliation is another way we describe it. You might be able to get an apology through a negotiated outcome. You might be able to get commitment by an employer to implement better training or work practices through a negotiated outcome. So under anti-discrimination laws, you can make your complaint of sexual harassment or discrimination to the Victorian Equal Opportunity and Human Rights Commission or the Australian Human Rights Commission, depending on if you go federally or state. And those commissions will use alternative dispute resolution to help you resolve the matter. Those are voluntary processes, and the goal is really to resolve the complaint through negotiation with the other party, with the assistance of a commission's mediator or conciliator. And then what will happen is that your negotiated outcome will be documented in what's called a settlement agreement. And that's a binding document on you and the other party to do what you agree in the document. In Victoria, you can also bring your complaint directly to VCAT, that's the Victorian Civil and Administrative Tribunal, if you don't wish to use the VERIOC dispute resolution process. Or you can go to VERIOC, that's the Human Rights Commission of Victoria, first, and then if it doesn't resolve in VERIOC, you can then go to VCAT. So it's the two options available in Victoria under the Equal Opportunity Act. However, in the federal jurisdiction, if you want to bring your complaint under federal law, you have to go to the Australian Human Rights Commission first. And if you don't resolve your complaint there through the dispute resolution process, you'll be issued with a certificate by the Commission and you have 60 days to lodge your matter in court. So that's anti-discrimination claims, Fair Work Act claims. Really briefly, I'm going to go through workers' compensation. Bearing in mind, I'm not a workers' compensation lawyer. I'm here to provide general information, and so I would be remiss if I didn't mention workers' comp. But with these matters, obviously you need to see a specialist workers' compensation lawyer. So workers' comp is a claim that can be pursued if you've suffered a psychological or physical injury at work because of the discrimination, sexual harassment, or bullying. This is a no-fault scheme, and every employer has to have workers' compensation insurance that applies to all workers and some contractors too. So they can't say that workers' compensation doesn't apply to you because you're not a citizen or a permanent staff member. You can also report unsafe work, or what's called a psychosocial hazard, to WorkSafe Victoria, who are the regulator. They have powers to send an inspector to site, and they might be able to investigate in certain circumstances. You can call them and they'll send you an online incident notification form that must be completed within 48 hours. You can find all the information about psychosocial hazards on the WorkSafe website under mental health, gendered violence. So if you search sexual harassment, it might not be obvious, but it falls under the category of gendered violence on the WorkSafe website. As you can see, there are a huge range of claims that might be available with different tests and different time limits. So, what is the timeline of a claim? What does it look like if you actually went down those paths? So you'd first start, or I should say that often what we see in movies or books is that legal claims are only in the courtroom in highly formal contexts, and you have lawyers and you have judges and people are all dressed up. It's not true. There are really lots of ways that legal issues can be resolved outside a court, and there are lots of informal, low-pressure environments, like we've discussed with the human rights commissions. Importantly, when you engage a lawyer, it is your role as a client to direct the process and make decisions on the lawyer's advice. It's not the lawyer's decision to decide if we're going to court or not. They're not going to force you to go to court if you don't want to. They're not going to force you to lodge a claim. It's really important for you to know that you drive the process as a client, and we give you the information and the advice about what your options are and what your chances are of success. So this timeline shows you from start to finish what a legal claim might involve and the various ways that you might be able to reach an outcome. So when you get legal advice, the lawyer will talk about those options for making the claim and which option will give you the best chance at resolution, depending on your personal factual situation. I should probably say at the outset, it's important that you need to decide what outcome you are seeking and what is really important to you to get out of the process. So as I said before, sometimes you can get an apology. You might be able to get training for staff or changes in the policies, but sometimes employers just aren't interested in making those kinds of changes. The lawyer will help you to contact your employer to make your complaint in the first instance. I've said here, so first step, advice, considering your legal options. You might need to prepare evidence at that stage as well, in order to show your lawyer what your claim is about and what evidence you have to prove the claim. So as I said, the first step will be contacting your employer, usually. This is the first step because the employer has an obligation to have a safe workplace for you, and particularly if you're still in the workplace. They need to perhaps do an investigation, and they might end up making findings about what happened, and the perpetrator might be subject to disciplinary action, for example. And for you, that might end up being the best option in all the circumstances. You might be happy because it's resolved this conduct, the conduct stopped occurring, and the person has been punished for it in the workplace. But sometimes that doesn't happen, and you might want to proceed to your external options. So the first step for pretty much all jurisdictions with a complaint is that you file an application. So as I mentioned before, it could be in the Fair Work Commission, the Australian Human Rights Commission, the Victorian Human Rights Commission, or in VCAT. So many options. You'd get advice on which jurisdiction would be, and you can't put one in all of them. You'd have to pick which one you're going to. And then the first step after you file your application is you're likely to have some kind of alternative dispute resolution. So a compulsory conference, a conciliation, or a mediation. Those are some of the words that we use to describe these. So VCAT uses compulsory conference, and conciliation is a term that we often use. This is a really great opportunity to resolve your complaint by negotiating with your employer directly, but you'll have a neutral third party assisting you in the room. Often what will happen is it'll be on the phone, so you won't even be in person, you won't be seeing them. you might be on a Zoom or a Teams call, or you could be in person. Those are starting to happen again, but they're not as common anymore as they used to be. Often you'll start in one room with everyone, or one phone call with everyone on the line, presenting your sides of the story. And then you might break out into separate rooms with the conciliator or the mediator going between you. It's called shuttle negotiation. If you reach agreement, as I mentioned, you'll document this in writing to settle your application. And I didn't mention this before, but what that will mean is that you withdraw it. You'll withdraw your application in return for the employer paying you whatever the negotiated outcome is. And that might be your compensation, your financial compensation, or any other outcome you've agreed on. Now, if you can't agree with the employer through dispute resolution, what will happen is that you need to go usually to a hearing, and it will depend where the hearing is, will depend on the jurisdiction you've chosen. At the hearing, you'll present your argument, and you'll have to have all your evidence ready to support your claim. And then a tribunal member or a commissioner or a judge will make a decision about whether you have proved the claim. In most cases, the requirement is for you to provide the evidence to support what you're saying. In adverse action, it's a slightly different test. It's called a reverse onus, and if you provide enough evidence to say that the facts have been proven, then it's up to the respondent or the employer to prove they didn't do the conduct because of your protected attribute. So that's another reason why you need a lawyer, to explain the different types of onus of proof in these cases. So if you have a hearing, the outcome will be determined for you by the court or tribunal. So this is one of the key reasons why a lot of people want to try and settle before you get to court, because it means you have more flexibility in what you negotiate. It means that you don't have the matter determined for you. You have more control over the process. And it also means usually that it's confidential. It means that you don't have to sit in an open courtroom and retell your story publicly. And usually decisions are public, unless there are orders that are made protecting the names of the people involved. So I should say, if you first lodge in the Human Rights Commission in Victoria and you want to go to VCAT, you need to file a whole new application, and then you might get another shot at negotiating in a compulsory conference for a hearing. Of course, that adds to the time that's been involved in making that claim. If you lodged directly in VCAT and you didn't settle at compulsory conference, you'll proceed to that hearing on the application filed. If you lodge in the Fair Work Commission, it'll depend on whether your matter involved dismissal or not. There's different processes involved. So as you can see, there are different opportunities along the way to get an outcome, and there are different paths that you can take. I mentioned time limits before. So Victoria, under Victorian anti-discrimination law, you have 12 months to bring your claim from the last instance of sexual harassment or discrimination. And that applies to both VERIOC and VCAT. For federal anti-discrimination law, you now have 24 months, and that's just recently changed, which is great news. It's now an equal 24 months for all types of claims in the federal jurisdiction. For employment law, if you want to bring an adverse action claim that relates to your dismissal, you've only got 21 days. That is a very strict time limit. And in fact, you need to argue that you've got exceptional circumstances if you want to bring your claim outside that 21 days, and that's really hard. However, if you're not bringing a claim relating to dismissal, you're only bringing a claim in relation to conduct during your employment, you've actually got 6 years, which is the general civil rules. It's a very different time frame. And then the stop orders that we discussed, as I said, you have to make them at the time of the conduct while you're still employed. I'm just going to quickly check the chat to see if there are any comments or questions. Okay. So this is the last part that we're going to talk about, some helpful tips. If you experience sexual harassment, discrimination, bullying, if you need to think about what you need to do to bring a legal claim. So a crucial part of this is gathering evidence and putting together legal arguments. One of the key things, as I mentioned, is that you need to prove that the discrimination or sexual harassment or bullying occurred. It's not normally enough for you just to say it happened. You'll need witnesses and you'll need other documents that can back you up. We know that these things don't usually happen on paper, and they don't often happen where there are witnesses involved. So it's really hard sometimes to get hard evidence to prove it. It might be your word against someone else's. So if you are experiencing discrimination, sexual harassment, or bullying, it's really important that you keep your own records, so that you know who said what, who was there, what happened. You need to describe the actions and behavior, even describing, for example, the tone of the voice that someone made the comments with. You need to have a record of what happened to you. How did you respond? Or how did the victim survivor that you witnessed respond? You need to know when it happened, like the day and the time. Have a chronology of the event, like a timeline. Where did it happen? The location. Sometimes that can be really important to know. Did it happen in the workplace? Did it happen during a work party or in a taxi on the way to the party? Were you there only there because of your work? And if you know why something happened, obviously noting that down. So witness accounts, yours and others. So you're wondering, how do I do this? If you're experiencing it, how do I have that record? How do I keep it? So you obviously could use a notepad or a Word file, keeping track of the day, time, location, and event. That's, absolutely fine way of doing it. Or you could buy a little pocket calendar to record these things on. Or one way that we've heard a lot recently, particularly in this technological day and age, is that you could actually just send yourself an email and directly afterwards, or as soon as you can remember, as that will have a date and time stamp on it. And that is very good evidence, because no one can refute that thing happened on the day, the time that you've alleged, because it's in the email. We should also say that if you get emails, you should download them and save them as a PDF file. And if you get text messages or WhatsApp messages, then screenshot them on your phone and save them to your phone. And if it's a work phone, save them to your home computer or your personal phone. Don't delete any voicemail files, download them if you can as well. We often hear about people in WhatsApp group chats that get kicked out of the group chat and then lose access to all of those messages. So really important to screenshot everything if you think that you're going to need to use it as evidence. So that's the paper trail that we're talking about on that second bullet point there. Records of work functions outside the workplace. So what are the things with sexual harassment that occurs outside the physical work environment? So at a work event, a work party, a gathering of just your work colleagues, after work drinks. It's good to have evidence that the employer planned or supported the event, or in some way endorsed or allowed it to occur. So that way the conduct that occurs at those events can be linked to your employment. What else? Copies of induction manuals or training on sexual harassment and discrimination in the workplace. Or if you don't have them, that's another thing to note as well, particularly if you're talking to a lawyer, that you've never been given any training and that your employer hasn't taken any steps to make the workplace safe and free from sexual harassment and discrimination. Pay slips that show your recorded hours of work are really useful as well. And then finally, medical evidence and treatment plans. So another key thing when you're proving a discrimination and sexual harassment complaint is the harm that the incidents have caused you. So we call this supporting documentation, mental health treatment plans, or letters from your doctor, health certificate of capacity. The medical evidence is always really important to show that impact. And that can then result in, it's really important for the part of the negotiation of the compensation that gets paid for hurt and humiliation, or when you're seeking orders from the court or tribunal about that compensation. So that's it. It's pretty complicated. And as I said, we always suggest that you get legal advice. I'm just going to check the chat again, and I'm just going to open it up to any more questions that you might have. It's a lot of information to take in. It's fine if you don't have any questions as well. So here are our contact details. As I said before, if you live, work or study in the Western suburbs, anywhere from Footscray out to Melton, you can get free legal advice from my team. The contact details are right here on the screen. Our phone number is 9749 7720. You can call and speak to one of our wonderful admin staff, and they can book you in for an appointment. Or you can email us directly. And again, if you have questions that you don't want to raise in this forum, feel free to send us an email, ELP, that's the Employment Law Program, @westjustice.org.au. And then the other thing is that we have a website, and the website has a web chat bot on it. So you can go to the web chat bot and it'll ask you some questions and it'll direct you in the right place to get some help. So that is the presentation for today. Thank you so much for joining me this evening. And if you want to book in, I look forward to hearing from you. But otherwise, have a fantastic night.